Welcome back to Conversate with Akeem D. Earle. And I am back with the most special guest, the official co-host of Conversate.
Mrs. Conversate with Akeem D. Earle. Shout out to Shala for my mug.
You were saving that. I never heard you say Mrs. Conversate. That's fire.
That's what it says.
Oh, D.
That's what it says. You never noticed that?
No.
Yeah, that's what it says. And it's got our alma mater on the other side. So it's my lipstick on it. But yeah.
Shout out to Shala. That's fire.
Shout out, yeah.
Dang. So if you want some Conversate merch, we have cups in different colors if you want.
You can text us because it's not on the website yet, but you should go check the website at conversatepodcast.com and we will work to get the merch up. Right now we have mugs and that's it.
And you heard it here first from Mrs. Conversate. That's fine. So the topic of today's episode is our first trial experience.
Oh yeah.
So I'm a prosecutor, which means on behalf of the state.
He the ops.
On behalf of the jurisdiction, the state of DC, I bring criminal charges for the different charges that DC brings charges for. And we take them to trial, obviously. A lot of them plead, but sometimes they go to trial. So I have had my first trial this past year. I'm up to 4 trials now. But
just finished a jury trial.
Just finished my first jury trial, which was insane. But we're going to talk about our first trial. I feel like that's significant.
Yeah.
Like, we did a mock trial together. And other people, I'm sure, have done mock trial, did different things, different internships. Yeah. But being a barred attorney, then doing your own trial, that's a whole different experience. For sure. So what do you do and why do you go to trial?
Okay, so I have, as a full-time job, left the world of litigation. I am a hearing examiner for DC DMV now. But on the side, I do have an estate planning, legacy planning practice that I do on the side, and I help people build their legacy, build generational wealth. Nice. So there's still trials kind of involved in that, but not as many as there were when I did do family law. And so as a family law attorney, that was fun. I picked that because that was kind of like the only job I really applied for outside of law school. I went to law school. I didn't really know what I wanted to do.
Yeah. Tonee is one of those people who's just good at everything. It's like a gift and a curse because she's so good at everything. She doesn't know what to choose.
I know. Like, I was like, I don't know what I want to do. I don't know what I would have fun at. And I think having worked already, kind of been in a career as a paralegal, it was kind of hard starting over as like the runt or like as the newbie or the rookie.
That's a fact. We're gonna have an episode where we talk about our paralegal journey because we were both paralegals. We have a lot to talk about. But we were both paralegals, and I agree. Like, going from being basically the lawyer's assistant to now having autonomy in your career is a big shift. So you say you did trials as a family law attorney. So let's first break down, what is a trial?
A trial is where so there's civil trials and there's criminal trials. Criminal trials is what Akeem does, and civil trials is what I do. Civil trials, there is generally a complainant and a respondent. Sometimes you'll have plaintiff and defendant, like in family law world. You'll have plaintiff and defendant, or otherwise you'll have the name of the person who is doing the suing and the person who is defending against the suing.
Yeah. You want to give a quick example
of something different, or
of like a civil, like what will be the caption of a civil trial?
It could still be plaintiff defendant. Like in family law in Maryland, it's plaintiff defendant. In estate planning, it's usually like the personal representative or the name of the estate versus like who's ever suing the or not even versus, it's the person who's suing the estate versus the personal representative in their capacity. So it really just depends on what your jurisdiction is and where you are. But you usually have some form of the plaintiff and some form of the defendant on opposite sides of the V.
Yeah.
And you're going because you want to go through the process of discovery. You want to be able to figure out, you think you have a claim against somebody and you want to be able to figure out, make sure that's true. And then when you get all of that discovery, all that evidence, you want to go to court and have the judge say, look at my evidence, now rule in favor for what I'm asking for.
So example I meant, like, so for like a civil trial, let's say you just got some new J's and somebody stepped on your J's and you're like, I will sue you. So you will be the what? If
you be the plaintiff.
I'll be the plaintiff because you stepped on my J's and I'm trying to come after you to get
You're the defendant.
Back.
Your defendant say, either I didn't step on your shoes, or if I did step on your shoes, I have a defense from having to pay you.
Okay, got you. Okay, that makes sense.
So,
and then for the criminal trial, it's usually the state versus the person who committed,
the defendant.
Yeah, the defendant, the person who committed the crime. So say somebody robbed a bank in Nevada, it will be the state of Nevada or the district of Nevada, whatever they use in that municipal, whatever court, district of Nevada against Jane Doe. And that's how it goes.
Yeah.
So do you want to start off
talking about? Can I tell my first court experience before I get into my first trial?
Mm-hmm.
So, because we had COVID, so my first trial wasn't really in person at a court. It was in person at our office, but it wasn't in person at a court. But my first in-court experience was at the DC Superior Court. And when you go into DC Superior Court, it's kind of like free range. Like, you just go to your courtroom. So there's lawyers walking around, there's defendants walking around.
There's no butlers or handlers. Yeah, like, where did you go? Yeah. I'll take you there.
You got the security, just go.
Right.
Figure it out. Don't get me wrong. Some people are really nice.
They have a help desk. They
do. So I go, sitting, I'm waiting for my client. I think it was a guy. I'm waiting for my client. I'm sitting down. I'm dressed to the nines. This is my first like in-person.
You want to make sure.
Yes. Yeah. I'm dressed to the nines. And he's probably a really sweet person. But this white man walks up to me and just starts talking to me about the case. And he was like, you're my client, right? And I was like, no.
Jeez,
and that was the most humbling experience, because I'm thinking, I graduated top of my class. I passed not one but 2 bars.
Talk about it.
And I'm thinking, and at this time, obviously, I hadn't passed 2 bars, but I know I'm
right, you
I'm some form of the ish, right?
Right.
And for him to look at me and just assume automatically,
right,
while I'm dressed the way, it really had me second guessing. Like,
you put in the work,
not even an attorney outfit. Like, it really had me second guessing. Like, that was just like, dang, am I supposed to be here? Because
what Jay said, still, come on,
right, exactly.
Because you put on your outfit, you dress the way you dress because you said, I want to present myself as a lawyer,
and I had like a pantsuit on, and don't like. I mean this in the nicest way possible, but don't get me wrong, most defendants not wearing no pantsuit.
Right.
Especially at DC Superior.
Yeah.
So, and again, they dress nice. Right. They do dress nice.
Yeah.
But they not wearing a pantsuit.
And sometimes you would think that you can tell the difference between who the defendant is.
You would think.
You probably had your purse, you had everything.
It was always, at least when I was with my clients, it was always just obvious who the attorney was and who was.
Yeah.
But you know what's crazy? I got that type of stuff. Not even just from, white people. Like, when I started doing workers' comp and my supervisor would take me to the different workers' comp places around the DMV, people would assume I was his client all the time. They would assume I was his client. And it was just, I don't know. It's just it's a very humbling experience, but it's also kind of depressing because you just wonder, like, why can't I be assumed to be the attorney? And again, it's nothing against those people. I'm sure they are used to seeing, people look a certain way when they come in as plaintiff, as either attorney or the client. But that was my first in court.
No, that's real. I just think it's just natural biases.
Yeah.
Like, we can do a whole episode on the history of the justice system, how it was used and was built and is used and is built to target a certain demographic of people. So the color of the person who walks into that courtroom and has a case against them is most likely a Black or Latino person.
Right.
So it is ingrained in the person's mind to think, oh, you must be the defendant and you must be the perpetrator. So it's like you can't hold it against them, but it's like,
Yeah.
come on, at least take the time.
Yeah.
To understand. He could have walked
Just
up to you and been like, "Are you Mrs.?"
Assumptions, right? Because
Right.
also you telling me confidential
without even like taking the time.
Yeah. You breaking the rules of professional responsibility.
Right.
So
and that happened the other day to a defense counsel, because when in my courtroom, sometimes the defense counsels, while we're hearing a certain case, other defense counsels could go to the clerk in the court and check in to say, "Oh, hey, I'm here. Call my case whenever you're ready." A black attorney, he had an afro, will walk to the clerk's table to check in while another case is going on, and the judge goes to him and says, "Oh, you're supposed to stand next to your attorney." He said, "Stand next to you, like you're supposed to sit there." And he was like, "No, I'm a defense counsel. I'm checking in." And I'm sitting there, I'm like,
that's disturbing.
It's bro, it's crazy.
I'm sorry, sir. Who are you? Like,
right.
Assuming I can't be here.
And that's the part. It's like there's no questions, there's no leading up, just to make sure like you're talking to the right person. It's I'm speaking automatically with feeling like I know exactly who you are.
And I think the hard part is like I can't get snippy with you.
Right.
Like, if I'm like, there's been a few times I've been on American and I've been in first class and I put my bag up and the lady's like, "Oh no, this is her first class," and I could turn around and snap at her like, "Ma'am, this is my seat."
Yeah.
But in the field, it's like, oh, I have to be polite about it. Oh no, I'm sorry, you got the wrong person.
Yeah.
I hate that.
Just to keep it professional, because you don't want to lose your license.
I don't.
And you can't go in front of the bar and be like, "Yo, they thought there's not going to be a good excuse to slap somebody's face off." But it is. We could fight. You set some precedent.
Yeah, exactly. And I feel like that I'd be well within my rights.
You would.
Nobody works that hard through law school to get mistaken to be as the defendant. Like, that's not fair.
I agree.
But anywho, that was my first in court experience.
Yeah.
And so my first trial experience was actually, it was fun. I was working at DC Affordable Law Firm. Shout out to DeKalb.
Gang.
They do amazing work. You should look them up. If you have the means, you should donate to them. They're this is not a sponsorship, but they're an amazing firm. They do great work for great people of DC. And so they gave me my first start as an attorney doing family law and estate planning. My first case was a family law case, without getting into any details or breaking any confidentiality or privilege rules.
Right.
Essentially, it was a virtual hearing. And I had a co-counsel, and she was awesome. And I think the hardest part was when you come into DeKalb, usually you're following up on someone else's work. So like you're getting yourself in the middle of the case.
Yeah.
And so you have to deal with the discovery that person before you did. Like they may not have asked for something you would have thought to ask.
And explain what discovery is, because you used the word a couple times. What's discovery?
Discovery is essentially gathering evidence. The discovery phase pretty much starts at the time a complaint is served and goes until a judge says it has to stop, which usually comes in like a scheduling order or 30 days before trial. And so discovery, you get to basically ask the other side for documents, to answer questions, information that is relative to your case. And so at DeKalb, there's the case we came in, discovery had already been done. And it was closed. We couldn't ask to get any more documents we may have thought would have been helpful for our case.
Yeah.
We just had to stick with the discovery we had. And so that was kind of hard because you're learning new things. And because of COVID, the case was spanning over years. Like the case, I think, started in 2019 and we were there in 2021.
Yeah.
So.
And sometimes cases do take that long.
Sometimes cases do take that long just in general.
Yeah.
But I think for this case, it was taking that long primarily because of like COVID kind of interrupted it.
Stopped a lot of stuff.
Yeah. And so the trial happens and I feel like we're doing really good. I feel like our client was a plaintiff and I think that they just had the upper hand and I think we're doing really good. But we get to my competitive nature and my my trial experience, and I don't think that my co-counsel may have done a clinic, but I don't know how much practice she got in trial experience. But she's a bit more timid. She's not as aggressive as I am, which was fine. I think I think finding the balance between both is very helpful in trial setting.
Yeah.
But there were things that I'm like, object, and you know how I am. Like, I'm so annoying. I'm like, you gotta object. And she's like, to what? And I'm like, to this. And, but it's hard because time is still going. Time is still going. So if the bell has been rung, if the person has said the thing you didn't want them to say and you didn't object, it's just out there.
Yeah.
And so I think it was my supervisor was like, well, then object. Like, cause my co-counsel wasn't objecting. And I'm like, she needs to object. Right. And I think it was my supervisor like, just go and object. And so I'm like, objection.
I got this one. I'll take it from here.
And the judge is like, excuse me, Miss Earle, you're not doing the direct. Or it was like something's like, you're not doing the direct. You're not doing the cross. Only one of you need to object at a time. And I'm like, okay.
Right. So how it usually goes is if I have a witness, I brought this witness to the trial and I'm asking him questions. That's my witness. And the other side gets to ask that witness certain questions.
Right.
And so while the other person was asking your witness.
So it was our client's cross, but I didn't do the direct of our client.
So your co-counsel did the direct. So she's if you did the direct of your witness, only you can now object to when your client is being crossed.
But it depends on the jurisdiction.
It depends.
Because I've been in Maryland courts where both people be objecting.
But sure, it depends on like preference of the court, but in terms of like flow and like getting in the rhythm for yourself, I find it easier. I would rather I object to my witness and you object to your witness.
But the thing,
cross objecting doesn't work for me.
But as a zealous advocate, if for instance, like if you have more experience than me, and even though it's my turn to object, as a zealous advocate, if you realize something about to come out that you know shouldn't be coming out, you have no choice because you have to rep your client with the best advocacy you can.
Right.
So as co-counsel, it's one of those things where it's like, I don't think our client should suffer simply because one of us is slower than the other.
Facts. That's true.
And I mean, that was my first reprimand from a judge at my first trial, but it felt kind of good. And I think a lot of times what you'll see is like there are cases where the attorney knows good and well they're not going to win, but they put on the best show. They're standing up, Your Honor, like they put on the best show, and that client is like, well, at least you tried. That client is still satisfied because they're like, well, I saw you go hard. That judge is tripping.
Yeah.
And so that's how I kind of felt. It was like, well, at least my client will know I did all that I could.
Yeah. And that's what it's about. It is about being a zealous advocate because you're going to have cases where it's a complete loser of a case.
Right.
Or the evidence is against you. He's caught in 4K doing the thing. Like, you just...
Yeah.
It's not going to be good.
Yeah. Right? So that was mine.
Yes. Other than, what other aspect of that trial was like new for you?
Honestly, it felt kind of like a mock trial. The rules were pretty much the same. We did mock trial my last year of law school, so it was virtual too, during COVID. So it very much felt like a mock trial. I think something else that kind of like popped out at me during the process of like discovery and just getting prepared for litigation was the opposing counsel. The opposing counsel was shifty. Like, he had been disbarred in Maryland, and we were just learning all this stuff about him. Disbarred in Maryland for practicing under his father's name.
Oh, Lord. What? Was he a junior or something?
I don't know. I can't remember.
Gosh.
He took our client's deposition, because it was recorded, because it was all virtual, and used it on his podcast to explain, like, basically why our client was in the wrong, even though his client ended up losing. But, like, used his deposition, and I was just like, he was just sketchy, like, shifty. And it was just, to me, like, I think that was, like, my first inkling where I was just like, oh, this profession ain't as glittery as they said it was.
There's a lot of people playing in the gray.
Yeah.
In this profession.
Because we were even debating, like, do we bring this up? And, like, obviously, it's all public record unless you request for it to be sealed. But it was very weird. It was, and, like, in my time at DCOF, there were a lot of seasoned opposing counsel, and each and every one of them were just kind of like, how are you still here? Like, how are you?
I feel like older attorneys, I mean, of course, speaking as a new attorney, I feel like they've been in the game for so long, they found the ways to like skirt the system a little bit, or find little loopholes to play in and use polls. That was crazy. That was crazy. That was that. All right, they found little ways to like get by on certain things, and it's worked. And it's worked because even me in my job, there's certain things defense counsel does, and I'm like, you thought that was gonna work on me? Like, you really thought you was gonna do that, and I wasn't gonna be like, no, are you crazy? Like, no, don't try to. And the reason why they try it is because it's worked before.
Yeah,
so they're gonna try these little games, and it's frustrating. But if it's worked for them, and they don't think that it's worth being disbarred for, but there is space to like skirt the lines a little bit, which is unfortunate.
There's really no rhyme or reason to a lot of the stuff that we do during litigation. Like, there's a lot of first, even as a seasoned attorney, like figuring out, well, how do I solve this problem? And it's like you never did it before because the court's always changing the rules, like depending on the judge or the clerk, they may have a different way of doing it. Opposing counsel might have a different way of writing their, joint parenting statement or what have you. So there is a lot of room to figure out just what can I get away with.
Yeah, especially in a space where you have clients.
Yeah,
you're trying to get them their outcome. You are willing to do everything you can to get them a favorable outcome. Right. So part of I feel like the intention is good. Yeah. But the method sometimes can cross the line. Yeah. Yeah. For sure. But so you felt comfortable speaking in the courtroom because of mock trial.
Yeah. I mean, with mock trial, you actually talk in front of judges, like not real sworn in judges, but you have people who judge you, and you get the opportunity to practice entering evidence into the record. So I did feel like, obviously I didn't know everything about trial work, but I did feel pretty good about public speaking. I also did Toastmasters, so
it's a good resource. Yeah,
it is a very good do Toastmasters if you can do Toastmasters. It's a really great resource. Yeah. And so that really helped kind of build my confidence. Yeah. Like the one thing I still try to work on is the silence for the ums and uhs.
Yes.
The nervous ticks that I do when I do public speaking.
A gem, a Conversate Gem. Yeah. Ums and uhs. I think that was like the first thing our mock trial coaches told us to like cut it out.
Yeah. Like any silence fillers.
Yeah. Chill with the ums and uhs. And even, my coach even caught like I do like a nervous like tick with my lips. Like I like press my lips together or like.
I feel like I pointed that out to you.
Yeah, it was. Yeah, it was either you. Yeah, it was something. Yeah, something where I like do something with my lips, and they were like, stop doing that. Yeah. And it's like these little things that you don't realize you've been doing for years. Yeah. But when you come to a profession, it's public speaking. That's what we're doing. Yeah. It's public speaking. You're gonna have to cut these things out because you may feel like it's natural to you, but to the person who's hearing you talk, is very distracting. Yeah. Ums and uhs, every other word in regular conversation to you is like, oh, that's fine. We say ums and uhs. When you're speaking, if you're giving an opening statement where you're talking straight for 5 minutes, ums and uhs is annoying. Yeah, it's like, please stop. I don't want to hear ums and uhs anymore because it makes it sound like you don't know what you're talking about. Yeah, you're trying to fill space because you're trying to catch what the next word is. But what they always told us, which is another tip, when you're prepared, you know the facts through and through, and you know your case,
you'll have very less.
And it was so crazy how true it was because they were like, the reason why you're saying ums and uhs because you don't know your case yet. And the moment we got our cases down, there was no ums and uhs because I'm talking because I know what I'm talking about. Exactly. I don't have to say, so he went to the bank, right? And he went to the bank, he entered the store, he pulled out his gun, and he robbed the bank because I know the facts of the case. So a tip. Take out those ums.
It takes practice.
For sure.
It takes practice. It's not gonna happen. Sure. I mean, I still do it. Yeah. So it takes practice. But be mindful of it. Yeah. Be mindful when you're like, I think I'll catch you. Yeah. You'll catch me. Like, stop saying stop saying So.
Yeah. But I think we've gotten a lot better because of mock trial, because we've been trained to catch it. Because even when we do it sometimes, we could hear it ourselves.
For sure.
Dang it. It called me because he kind of didn't know where to go next. So I said, oh, that's crazy.
So your turn. So tell us about your first trial experience.
Yes. So
set the scene.
So as I said, I'm a prosecutor, and my office prosecutes DUIs, which is driving under the influence. And that was my first trial. I was second chair. Second chair means that there's a first chair. Obviously, it was the lead attorney, and I was co-counsel on the case because they weren't about to throw me into my first trial by myself. Even though sometimes that has happened.
Sometimes they do. They're like, good luck.
Right. So I was doing a direct examination of about 2 officers.
Oh, we didn't explain what direct.
Right. So the makeup of a trial is there's an opening statement. Each side gets to basically paint the picture for either a jury or for the judge.
The fact finder.
The fact finder. And if it's in front of the judge, it's called a bench trial. If it's in front of a jury, it's called a jury trial. The reason why there's a difference is because some charges don't find a need for there to be a jury, because they're not about to like bring in a jury for possession of alcohol in public, like, because that's not needed to take people.
Can't they request a jury?
Only if it meets a certain threshold. If you're facing a certain amount of days in jail, stuff like that, then if your charges are enhanced, then you could call in a jury because the stakes are higher, basically. But if you're caught with a if you call it a BB gun, which is a criminal charge in DC. If you go with a BB gun, they're not about to ask 12 juries to take 12 people to take time out of their day to hear a possession of a BB gun case. It's just flow of the court, and it's easier process for the judge to just hear that trial, and him be the fact partner. And there's other factors that go into jury and judge, but those are the 2 different type of cases. Okay. So there's an opening statement that you're telling the judge or the jury, and it's basically each side painting a picture for the fact finder, saying, hey, yo, what you're going to hear today is that Susie walked down the street and she tripped and busted her knee. Right. And we are bringing a case against the Department of Transportation because the Department of Transportation should have fixed that crack. Right. And we have evidence that 2 years ago, they knew about this crack and they never fixed it. This is why Susie needs $100. Oh, wow. So you're paying the picture, and then the Department of Transportation will be like, no, that is in fact not true. What you will hear is that sidewalk doesn't even belong to us. That sidewalk belongs to Jane, who is the owner of that sidewalk because she bought it 3 years ago. So so basically you're painting the picture. Right. And then there's the direct examination, what we talked about. You get to put on your evidence. You are talking directly to your witness that you brought to court to help your case. And then the other side gets to cross-examine, which is exactly what it means. You're crossing over and speaking to the other side's witness. Mm-hmm. And you're basically asking them questions. Right. And you're asking them like, you didn't really see that. You didn't really do that. You didn't really hear that, did you? To help your case and basically to discredit them as a witness. Mm-hmm. And then however many witnesses you want to bring, you do that. And then there's closing arguments, which is a segment of the Conversate. That's where I got the whole segment from. Mm-hmm. There's closing arguments where you basically wrap up the trial. Mm-hmm. You're saying what you heard here today, you saw evidence of Susie, you saw a video of her walking down the street, and you saw pictures of her scraping her knee. And we even showed you evidence of the forms that D. filled out to say that this is what they own that piece of the sidewalk. So this is why you should give Susie $100. Mm. And then D. will come back and close and be like, what you in fact heard today was that we didn't own that sidewalk, and yada, yada, yada. So you're just closing it up, painting the picture again, but you're painting it around what you presented through direct examination and cross-examination and the evidence that you submitted to the court. So I did direct examination in my trial for the officer. It was a DUI. Again, not to disclose too much information, but he was driving down a highway, cuts off a woman, and then like tries to like swerve around her, but he loses control of the vehicle, crashes into a barrier, and then decides to just get out of his car and like walk miles down the highway. And at first the police thought he was like, he needed some help, but then he started like ducking from the police. He started like ducking in and out the bushes, trying to hide from the police. And when the police found him, like, yo, what's good with you? Like, what's wrong? When they found him, they smelled alcohol, his eyes are red, different stuff like that. And he claimed like he was trying to find the police station. He was like climbing through the bushes, stuff like that. So it was a difficult case because the evidence wasn't on our side. It was certain things we couldn't bring in. But the main thing, I agree with you in terms of my trial. I felt comfortable speaking in court. I felt nervous. Like right before I start, and I realize this now, right before I start a trial, my heart like sinks. like right before the judge goes, now, government, you may begin. My heart like sinks. And then, but the moment I start speaking, it calms down. It calms down all the way because like, once I start getting in my flow, I'm like, okay, I'm comfortable here. I know what I'm talking about. I prepared for this thing. I don't have to be nervous. But I still feel like I like that nervousness because I know that I'm still passionate about this thing. So I definitely felt that the first trial. But the moment I started talking and asking the officer, like, where do you work? What do you do for a living? How long have you been an officer? Like, it just starts to flow. It starts to have a conversation. And that's what I do on the podcast. I feel like that's just a gift I have, just having a conversation with a person and extracting evidence. And that's what direct examination is. You're having a conversation with a person. You're trying to get out as much information as possible. And that's what I do on Conversate. Like I'm asking you follow-up questions and I'm trying to get the most information. Right. The most information as possible. You're not going to be investigative in a podcast. That's the same thing.
So let me ask you this. As like a family law and estate planning attorney, when I go in court, I sometimes like my heart kind of like sinks because it's like I'm dealing with the lives of someone, you know. Is that the same as a criminal prosecutor? Like, do you be like the fate of the district in my hands?
No, it doesn't feel like that. Also, because the cases that I do aren't that, they don't have, the stakes aren't as high as like a federal charge. No, it takes a lot to get to trial because you're offering pleas, you're offering diversion programs, you're offering all these different things. And most times, I know in my office, we're trying to help the defendant as much as possible. If you have a drinking problem, if you have a drug problem, there's a lot of different diversion, different programs we're going to put you in and we're going to offer you to make sure you're secure. Now, if you got like 5 DUIs, we go to trial. Or we're giving you a plea, you're probably not going to like the plea, and you're going to go to trial. So by the time we get to trial, it doesn't feel like, oh, the state of the district is in my hand. You're just trying to do the best job possible.
But if you don't win, if they're not found guilty and you just like knew based off the evidence you collected that they should have been, what is the feeling?
Sometimes you can't take it personal because you have to work with the evidence that you have. And especially if you know you prepared as well as you could and you presented the evidence the best way possible and the judge still says not guilty, then that's fine. Like you can't, you're not going to hold it against you. Like, oh my gosh, I can't believe I let this. No, sometimes it's out of your hands.
Yeah.
It's out of your hands. Even the jury trial I just did, it was great evidence. I feel like we did a great job, but the jury could have came back and said not guilty.
Yeah.
And we would have been shocked, but it would have been like, that's how it is. Yeah. They just see things differently. As much as you try to paint a certain picture and tell a certain story, it's up to the fact finder you're hoping that the fact finder sees it the same way that you do. So I don't take it personally if I lose a case or if the person is found not guilty, because that's a process. Yeah. That's due process. Like, we went through the process. He was charged with a certain crime. He went to trial. We put our best foot forward. We presented evidence. His lawyer presented evidence, and the fact finder found what they found. Wow. And that's what it is. That's the process. You have to be okay with the process. Yeah. You can't, especially as a prosecutor, the moment you start going into like wins and losses, I feel like you've gone down the wrong path, because now you're gonna try really, really hard to get wins that you don't want to, and that's where you start crossing lines that you shouldn't be crossing lines. Yeah. You should be happy with, was due process done? Was I prepared for this case? Was this person treated the best way possible? Because as a prosecutor, we have the highest level of responsibility to hand over all of our evidence, whether it's exculpatory, which meaning that it's evidence that shows the defendant is not guilty. We hand it over, every little thing. We hand over. If it helps you, if it hurts, it doesn't matter. We're giving it to you because that's our responsibility. Because our job is not to just win, it's to bring justice and whatever definition you want to have of that. But it's our job to bring justice. If you were drinking and driving, you know it's a crime, you put yourself and other people in harm's way, and we have the evidence against you, we're going to bring the charge against you, whether it's a plea or a trial. And if you go to trial, you're going to work.
Right.
Yeah.
So you've done 4 trials.
Yes.
Do you enjoy litigation?
That's a loaded question. Litigation as a whole is not just going to trial. Like you said, litigation, at least for a prosecutor, is having a caseload of like over 100 cases, different charges, speaking with defense counsel, speaking with arresting agencies, speaking with the DMV, speaking with all these different agencies. You're watching a lot of video. You're reading a lot of documents. You're organizing yourself. You're also in court, in front of the judge about 3 times a week, sometimes more. Going through your office's case is called calendaring. So like say...
So are you saying no, you don't like it?
I'm saying I don't necessarily like the administrative side of it. Although it has grown my like organizational skills and I've built a system to make sure I'm able to handle all these cases, I'm not too fond of that. I love going to trial though. I love trial work. I think that's fun because...
So if you could be in court all day, you'd be fine.
Not court all day. My dream situation would be to have, like, I told you, I want to be the assassin. Call me in where you need trial. Give me all the documents. Give me all the information. When it's time to go to trial, you call Akeem because you know he a sniper. I go into court and I win your case for you and I go back home. I don't got to deal with having 50,000 cases and do all that stuff where you try to, and that happens a lot in like entertainment law. I interviewed a couple of entertainment lawyers, trademark lawyers, copyright lawyers, and they said their job is to not go to trial at all because they want to make sure the contracts are set up where your client does not have to go to trial, which is great. But life happens, and sometimes things get missed in contracts, and sometimes people go to trial. And those attorneys who handle the contracts don't like going to trial. That's why they went into contract work. So they will outsource their work to trial attorneys, and that's where I will come in. You call in the assassin. That's my dream position, where it's like, just call me in to do the trial work, and I got you.
Gotcha. Okay.
Yeah.
Okay.
Yeah. I think it's fun, just like going through the evidence, building your case, and like I said, you're telling a story. You're telling a story for the jury, for the judge, and you're saying this is what you should believe.
Yeah.
And it's really the best man wins. The best story wins, regardless of what the evidence is. Because we've seen people win trials on a little bit of evidence.
That is true.
But they painted the picture amazingly.
Yeah.
Amazingly.
Yeah.
So, yeah.
Okay.
Yeah.
Fair enough.
Yeah.
I don't like litigation.
Yeah. Yeah, she does not. She hates it.
I don't.
Yeah.
I feel like I don't like the I don't know like the perfect word for it, but I don't like the connivingness that comes with litigation. Like I don't like.
Now, are you speaking from your own personal situation, or do you feel like it don't matter what space you're in, there's always going to be some connivingness?
I don't think it's not going to matter what space you're in. Like I feel like we get clients that we know are in the wrong, and we'll gas them up like, no, like. The judge should do this. Like, it should come out this way, knowing good and well you a whole, horrible person who should not get full custody. But we gas them up and like, even opposing counsel, like, even if it's not me doing the wrong, you're going to have opposing counsel who's like, well, she did this and that. And like, just makes it seem like I should care. That you're making up stuff about your client and I'm just supposed to run with it. Like, I don't know. I just wish that like it could be as simple as like, okay, this is what we have and I should be able to tell my client in reality, this is what the outcome is going to be. And then the other opposing counsel should be able to tell their client, okay, in reality, this is, instead of like, you could get this and like highball it because it's all about the money. I don't like that.
You wish it was always about the truth.
I wish it was always about the truth. I wish it was, especially.
Welcome to the profession.
Right. Right. Especially in family law where you have children involved. I wish it was always about the truth. Because you won't scar that kid. And sometimes there's not enough therapy in the world to help a kid get through what their parents put them in the middle of. And I just hate that for them so bad.
Yeah. It's on the criminal side, because we ask defense counsels like all the time, how can you defend somebody who you know you did it? And the defense counsel will tell you most of their clients are guilty. They know they did it. But it's about they are owed their time in court. They're owed due process. And if they're owed due process, you don't want to be like, well, I know you're guilty, so I'm not even going to try. Like, no. You paid me to do a job. I know you're guilty, but I'm going to do the job the best I can.
You see,
how do you address that?
I can kind of respect that a little bit more, because if I get a client that's like, look, I'm not going to tell you whether I did it or not, but the evidence might show that I did it. At that point, it's like, okay, so here are your options. I want to be able to give my client, you can plead guilty and it'll probably be better for you because of X, Y, and Z. Or you can go to trial. But if you go to trial, it could be worse for you because X, Y, and Z. And the evidence doesn't help you.
But but if you say you like the truth, the defense counsel will say, I'm going to try my best so that you win. Even though I know the truth is that you're guilty.
To me, I if I was a defense counsel, I wouldn't say I'm going to try my best so that you win. I'm going to do the best that I can so that justice is served. I feel like
clients don't want to hear that.
Exactly. I'm an attorney that wouldn't make money.
They're like, yo, can you get me off or not? They're not trying to hear I'm going to do the best I can.
Stick with
so
estate
justice.
planning.
That's so vague.
That's why I stick with estate planning. Would you like a will draft? I can do that for you. That's not adversarial. You need a power of attorney? I got you.
Oh,
that's not adversarial. It's the adversarial part of me that gets me every time, because it's just like, why are you fighting me and you know you're wrong?
Right.
You know, and that's the reason why the court system is so backed up. Because you have these frivolous cases going to trial that could have been settled. You could have just came to your senses and recognized. And don't get me wrong, particularly in the criminal justice system, I do recognize this. Sometimes there is an imbalance when it comes to serving justice. I do recognize that there are people who can be spotted as, you know, the suspect, tried. They could completely not be the suspect, but because the way the evidence stacked up, they went to jail. I completely get that. But I feel like 9 times out of 10, you know you did it.
Right.
And I feel like
people be caught at 4K. That would be killing me. Like, people want to call me the ops and prosecutors. Yo, these people be caught at 4K, yo.
Right.
4K sometimes.
And I feel like I think some people know the system.
Yeah.
They know it's better off to fight it, because likely than not, I could get off. Yeah. But then in those chances when you go in jail for 75 days and you could have went for 3, it's like, you got to weigh the balance. You got to weigh the risk of, you know, telling the truth or not.
Yeah.
But in hindsight, I realized I should never went to law school.
Really?
I didn't want to do this.
What?
I didn't want to do this. People just kept saying I was good at arguing. That's all it was.
And she's really good. She could be a beast criminal lawyer, whether prosecutor or defense counsel.
Because it's the competition of it all. That's it. Yeah. It's knowing that it's a V in the middle. It's the competition of it all that excites me. That's why I really did enjoy mock trial, because
you just want to win.
Yeah. I just wanted to win. And I feel like with family law, that was how I started. It was like, I just want to win. But then I realized there's no passion in this. Like, I'm helping you win and you're a horrible person.
Yeah.
I don't want to do that.
I know for sure you're going to abuse your kids.
Right. Or I know
you don't even feed them.
I know for sure she should get half. But I'm going to protect every single dollar you have. No one good or that's going to leave her out. You know?
She's going to leave with half.
That's the way it was.
18 years. 18 years. That's crazy.
You should have married her. She got prenup.
And found out it wasn't his.
Look. I shouldn't have did this. I am glad
you're finding other areas of the law to help people.
I am. I'm glad estate planning exists.
Yeah.
I really am. I love helping people. And I love that with estate planning, I'm rarely in court. Rarely. Yeah. It has to be somebody is contesting a will, someone is contesting probate, and then maybe we go to court. But I really do try my best to be as transparent as possible with opposing counsel to let them know I ain't hiding nothing. Like, this is what it is. Don't. And sometimes you get that opposing counsel who wants to rack up that dollars on their end. So they're going to tell their client, well, she says this, but can you believe her?
Yeah.
And, you know,
I do think it's based off of your experience, because I entered for a family attorney and I could not do it. I could not find myself doing a family law. Like you said, you're dealing with children and marriage, and it's a whole lot of feelings involved that goes past the black letter law. Like, you're dealing with a lot of things, and you're gonna get the shiciness and the connivingness because this scarred ex-wife is going off of this abusive ex-husband, and it's way more than what the family law says. You're trying to skirt your way around. I'm trying to beat him. You have clients that don't care about the money, who don't care about the child. They just want this person to suffer.
Exactly.
That's all they want. That's different.
It is.
That's different from, like, we don't have to get our feelings involved in criminal law, where it's like, from the defense side, for a lot of counsels, it is personal, but it's like, these are the facts. These are the charges, and here's what I'm laying out. It's not personal. It's not like, obviously somebody's life is on the line, but you're not trying to get at the person just to get at the person.
Yeah, if you put on a defense that knocks my evidence to shreds, then great. Great for you, right? Yeah. Like, that, it's no skin off my back. Right. You didn't do it. All is well. Right. You know? I definitely get that. And I'll say, like, that's why I really did enjoy my time at DCALF, because for indigent clients, it's just different. Like, I could get that crappy opposing counsel on the other side, but for the most part, those clients just wanted what was right. They just wanted the child support they were owed. It wasn't about, it really was like, what does the calculator say? Like, it wasn't about, oh, but he got this, and this. They really just wanted what the law allowed. Yeah. And I appreciated that. And for those clients, I would fight for that. We had one client who he just wanted to rightfully claim his child. And there was the child's mother had passed, and there were people arguing that, like, no, I should be the child's custodial parent or person. And the father just wanted the child. He just wanted to be the person who could take care of his child, and he was taking care of his child prior. It just, he just hadn't done the paperwork. So for him, I would go to bat, because it's not about being petty. It's not about it's about getting what the law allows you to get. It's about getting what the law says you should have. Yeah. For those type of cases, I would take those in a heartbeat, because the competitive nature in me will win those cases. I will win those cases, and I'll feel good about it.
So it sounds like you don't regret going to law school, because we are a podcast. We're trying to encourage people
go to law school.
To go to law school, for one. But I think every profession, every person in whatever field they're in, they have moments where they're like, why the heck did I choose this path? And they also have moments of I'm exactly where I'm supposed to be. Yeah. And I feel like you've come across both sides of that. And instead of saying or feeling like I should have went to law school, it should be like, let me move more to the spaces that I actually enjoy practicing.
No, I'm not saying I shouldn't have went to law school. Law school was so much fun. Like, law school was a grand old time. Right. I'm saying I should have been a lawyer.
You should have got your JD and did something else.
I'm saying I'm glad I went to law school, but maybe I didn't need it. Maybe I didn't need it. I had a grand old time. And I think I see a lot of people who, they go through law school, they get in the field, they get barred, they practice for a few, and then they're like, this isn't fun. This isn't fun. And I think that's the issue. The field is so big. You don't know what you should do. And ain't nobody trying to do entry level for the rest of their life.
Right. And I know life is long, but you don't got enough time to like try out every single. There's so many areas of law.
You don't. Yeah. You don't. I mean, go to law school. If you feel like you want to go to law school, you should absolutely go. It is not for the faint of heart, but it is a really great experience. Like, you meet such great people. Your professor, we still hang with our professors. We have such a great class of people who we've gotten to know, who we create businesses with, and we do partnerships with. So go to law school, because it is an amazing experience, but just make sure it's what you want to do.
Yeah. And I mean, you're not going to find out until you do it.
Yeah. Well, I did see I don't know if it's BALSA, Black Law Student Association.
Mm-hmm.
There's some program out there where you can forego your first year of law school and like clerk or like work as a kind of like law student or whatever.
That'll be fire. Fire.
In a nonprofit organization, and you get a salary and everything.
Oh, yeah.
And I was like, yo, where was this? Because that would have been it for me. I would have been able to know.
Yeah, because law school is great, yes, but when you become a lawyer, you're kind of learning all over again how to just do the job. Law school doesn't teach you how to do the job, but I always say the faster you get to understand what it is to be an actual professional and to do the work, the better it is for you, because you're coming out of law school very just like in your books, very to the letter, briefing your cases, which is great. But when you come out of law school and you're dealing with people, you're dealing with personalities, you're dealing with systems and the way certain things operate. Like I said, having over 100 cases, how in the world do I handle that?
Yeah.
They don't teach you case management in law school. They don't teach you the best way to organize your files and where to put your discovery and where to put your evidence and where to put contact information. They don't teach you that. You just have to learn. So I think the faster you get to those spaces, the easier it will be for you. But
for sure.
Yeah. So just to close it off, one last tip. What do you think is the greatest tip for somebody going into their first trial? They're watching this. Their trial is next week. They're prepping. They're going over their case with their co-counsel. What is it? The number one tip you're telling them right now?
I feel like I have like 3 tips.
Okay, we can give 3.
Make sure you know your facts. 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 Practice your objections. Practice responding to the objections that the opposing counsel might make. Practice saying objections to the evidence the opposing counsel might try to get in, especially if you can know the evidence ahead of time. So that also encompasses know your court rules, know how evidence is allowed to be presented, and if there was a cutoff and they're trying to get something in they hadn't shared or put on a pretrial statement, then you can object to that. And then lastly, I would say come up with like a preparation mechanism to help get the nerves out. I put on an alter ego.
What's her name?
Lene.
Lene, oh Lord.
I envision, so Lene's my middle name. I envision Lene, if I was like, name Lene, she'd be hardcore. Like she wouldn't take nothing from nobody. And I put that on, and that's who's at court. I can't blame myself. I just blame Lene if anything goes wrong. Yeah. So those would be my 3 tips.
Yeah.
What about you?
I'm just gonna piggyback off of yours. I feel like those are great. Specifically, knowing your facts. I've found that a lot of people say it's hard to find creativity in the law, but I found that when you're going to trial, there actually is a lot of room for creativity in terms of based off of the decisions you can make in trial. Decisions when you're directing a witness or crossing, because when you're in trial, there's so many moving parts. You have to be present, you have to be on point. And I feel like in order for you to be present and in order for you to catch the objections and to not be nervous, you need to know your facts. The trial before my last one, this past one, I was able to impeach somebody, and it was really fun.
What is impeaching?
Impeaching is basically you're catching the witness in a lie. So on cross, I was able to be like, you testified to this, but that isn't what you said, isn't it? In fact, I have right here on video you saying this, and he was like, "Oh no, I didn't." I said, "Bet, showing this is what you said. Is this what you said, right? Oh, maybe it is what I said. Yeah, that's impeaching," and it felt really good. And I was able to do that because I knew the case cold. Because I heard him say a lie. I heard him say something that wasn't in my facts, that isn't what he said, and I was able to catch him on it, and it was effective. If you're not prepared, you won't be able to do that. If you don't know all the cases, or if you don't know all your facts, the witness could say something, and you can't catch it because you don't know what's what. You know, oh, that sounds right to me because I don't know it. And there was creativity in that because you write your cross basically where you're in trial. I found that for creativity to come out where I was able to form my cross around that, or my witness is saying a certain thing, and because I know the facts, I'm going to curve him a certain type of way, or I'm going to direct him a certain type of way, or paint the story a certain type of way with my questions, so that I could get to a certain point because I know my case. So I would say for you to be able to be fluid in trial, and for you to be able to be free and calm, know your facts, know your case back and forth, know all the cases that you need, know all the objections that you need to object to, because that will make you feel comfortable. You're going to be nervous in the beginning, but it won't be anything compared to when if you don't know your case,
Right.
somebody says something crazy or some facts come out and you have no response to it. And that was my big I was helping out some mock trial students from our Armada the other day. And that was my biggest thing. It was like, bro, y'all can't afford to not know your facts. And you don't go up. The other side is not trying to help you. They don't care. They don't care if you look stupid. And in fact, like you said, they're on the other side of the V. They're trying to take you down.
Yeah, they want you to forget the facts.
They want you to forget.
They want you to slip stuff in.
Bro, they want you to look crazy. So in order to prevent that, know it cold. And I feel like that would do a lot for you more than you think. It's more than just, I just know it. It will guide you through the entire trial, and you'll be comfortable. You'll be more confident in that space. You're like, no, Your Honor, object. No, this is not what was said. This was not what was shown. Your Honor, this is facts, not an evidence. Your Honor, this is not what was testified to.
Yeah, learning how to lay a foundation.
Yeah.
For law students, do mock trial if you can do it.
Yes.
And make sure it is a competition team.
Yes.
Make sure you are learning how to compete.
Yes.
Learning the rules of evidence.
If this is what you want to do, if you want to be a trial attorney.
If you want to be a litigator.
Yeah.
Specifically a trial attorney.
Yeah.
Do mock trial. If you could do, if it was between law review and mock trial, do both, honestly.
Yeah.
But mock trial is a big.
I'm an advocate for. I'm team mock trial. I feel like law review gets all the love, and mock trial don't be getting all the love.
I feel like law review is dope, and it is particularly helpful if you plan on going into like the teaching field, because you need to be able to be published. And so you kind of know the ins and outs of that. But if you aren't really looking to have like an academic background when you graduate,
going to big law,
or going into big law,
yeah.
But you can also clerk. You can clerk without doing law review. So if that's kind of your way, I would definitely do mock trial.
Yeah, because I always like mock trial is helpful because you're talking in front of people you don't know, and there's no different than when you're an actual attorney doing a trial. There's no introductions. There's no hi, my name is. Oh, there is a hi, my. But there's no like going around the courtroom and shaking hands with each juror and introducing yourself to the judge. Like, hi. What's one thing you like about yourself? Right. Or what's one fun fact? There's no like breaking the ice. It's like, good morning, Your Honor. My name is so and so for so and so.
Yeah.
Other side goes. My name is so and so. Let's go straight to war.
Yeah, and there's nothing.
First piece of evidence, go. Opening statements.
Exactly. There's nothing more satisfying than being able to like say something snarky. Like Adam.
Shout out to my guy Adam.
Adam, whenever like someone did like a relevance objection, he'd be like, Your Honor, relevance is such a low bar.
It's the lowest bar.
It's the lowest bar.
There's no lower bar.
I love that because like you're not expecting that.
Yeah.
But Adam is just like, and that's part of knowing.
Oh yeah.
Your rules.
Yes, like, knowing your stuff. It definitely feels good to make somebody feel stupid.
It
Make
does.
sure it looks stupid.
It does.
But it's in the smoothest way possible.
Yeah, no better place to do that than mock trial because
yes,
you go up against schools who really just don't know. They didn't practice. They don't know. And so they object to something and you're just like, Your Honor, the rule is this.
Yeah.
It's amazing.
Yeah. So obviously we're team mock trial. Yeah, if you want to be a litigator, if you want to be a trial attorney, mock trial is the way to go. And yeah, this has been the episode on our first trial experience. And we'll be back with more episodes. It's been Conversate.